Maritime Malta Legal Perspective. The term Maritime Malta perfectly describes Malta, a country which has always had close connection with the sea and maritime sector. Malta's position in the center of the Mediterranean, equidistant from the Strait of Gibraltar and Suez and the shore of North Africa and Italy, means that it has always been considered a highly strategic trading post. Malta's existing maritime diversity is evidenced by the fact that it has the largest shipping register in Europe, has one of the deepest natural harbours in the world, in home to numerous marinas which now welcome some of the world's most glamorous super yachts, has a tradition in ship repair with numerous yards and docks, one of which is 230 meters long, has two fascinating ports of call, Valletta and Gozo, for the hundred of cruise liners either visiting Malta or using it as a home port. Is equidistant from the Strait of Gibraltar and Suez and thus an ideal bunkering location. Boasts an international port, Malta Freeport, which serves as a highly successful transshipment center and is home to the International Maritime Law Institute, a postgraduate academic institution under the auspices of the International Maritime Organization. These achievements are a direct result of careful planning, a strong workforce that is prepared to deliver value for money, and a can do attitude. In addition, Malta has a stable and reliable legal regime and laws which give investors and their financiers a high degree of confidence. Overview of legal system. Before Malta became a British colony in 1801, it had a fully developed judicial system based initially on Roman law and later on the Napoleonic Code. When the British came to Malta, they found a highly developed legal system. That said, the years under British rule were extremely important in terms of shipping legislation, as a number of shipping laws passed in England during this period came into force in Malta. Following independence in 1964, a number of important commercial laws passed by Parliament were based on the British model. This includes several laws in relation to financial services, shipping, and companies. This coupled with the fact that English is the second official language in Malta, which means that all legislation is available in English, ensure that investors and their financiers are guaranteed a high level of confidence. As English is an official language, there is often less bureaucracy compared to the other jurisdictions, where everything from a simple power of attorney to the most complex corporate document must be translated into the working language of the respective country, notarized and apostilled. Malta has a diverse body of maritime laws to sustain its maritime activities. It is universally recognized that having a solid legal base which provides potential investors and their financiers with the confidence that their investments are secure is paramount. Without it, no country can aspire to have good quality high-end investment. In addition to the laws passed by the Parliament, Malta is a signatory to an increasing number of international conventions regarding the maritime sector. Further, as Malta is a member of the European Union, it is subject to the entire body of European law. International Convention Malta is party to a number of both well-known and less established international conventions, and these conventions are a major part of its body of law. The more well-known conventions include the Safety of Life at Sea Convention, the Prevention of Pollution from Ship Convention, and the United Nations Convention of the Law of the Sea, UNCLOS. Malta helped to launch the discussion of the establishment of UNCLOS on November 1, 1967, when Dr. Arvid Pardo, Malta's permanent representative to the United Nations, made a heartfelt appeal before the General Assembly highlighting the need to protect the ocean and take all measures against pollution. It was Parder who, based on Malta's historic position, argued that the seabed on ocean floor should constitute part of the common heritage of mankind, a phrase now contained in Article 163 of UNCLOS. Local legislation. In terms of local legislation, there are several laws which regulate every aspect of the maritime sector. Perfect example of Maltese maritime law are the Merchant Shipping Act and the several pieces of subsidiary legislation promulgated under the Act. The Merchant Shipping Act is the undisputed authority for the maritime sector. It regulates numerous pillars of maritime law, including the registration of vessel, the registration of mortgage, masters and seafarer, safety at sea, pollution, special shipping inquiries, wreck and salvage, and shipowner liability. Many other legal notices and subsidiary legislation have been promulgated under the auspices of the Act. Combined, these laws establish the entire body of law regulating, among other things, collision at sea, training and certification, load line rules, the limitation of liability on maritime claim, safe manning and watch keeping, shipping organization, and the certification of commercial yachts. The Merchant Shipping Act has been fine-tuned and constantly updated to the extent that the Malta flag is now the European-wide listed flag of choice for hundreds of ship owners. The reason behind the flag's success are mostly operational in nature and include English being an official language, the tonnage tax regime, and the regulator's ability to offer a continuous service where necessary. Further, as Maltese law offers a great deal of protection to financiers, it's attractive to investors. Ships are often financed by third parties. The mortgagee must believe that the law of the flag state properly protects its interests, otherwise, the financier will refuse the owner's chosen flag. As such, the choice of flag is an important consideration. Maltese law also protects mortgages against defaulting owners, one of the reasons why the Maltese flag is so successful. Further, under Maltese law, mortgagees are in privileged position because the mortgage itself constitutes an executive title. This means that the mortgage is equivalent to a judgment. Thus, in the case of a defaulting owner, the mortgagee need not commence an action on the merits against the mortgagor for defaulting on its payment. Any other normal creditor would have to commence an action, make a case in court, obtain a judgment, and then enforce the judgment. Under Maltese law, mortgagees have a number of available options to enforce their right. Thank you.